Hello and welcome back. GovDoc News, no opinions, just facts and summaries, government documents. You do the rest. All right, back with the Supreme Court order October 15th, 2025 in the case Crawford v. Mississippi. And again, we have another denial of certiorari from the Supreme Court. So let's see what's going on. In 1993, Charles Ray Crawford was charged with kidnapping, raping, and murdering Christy Ray in Mississippi. He pled not guilty, insisting he was innocent, and wanted his lawyer to fight the charges by challenging the prosecutor's evidence. Crawford was clear in his instructions. He wanted his lawyers to pursue a defense that maintained his innocence and forced the state to prove every part of its case. However, Crawford's lawyer ignored his instructions. They believed he had committed the crime and chose a different strategy. They admitted to the jury that Crawford killed Christy Ray, but argued he was not guilty by reason of insanity. They made these admissions during jury selection, opening statements, and closing arguments, even though Crawford repeatedly objected. Crawford wrote letters to his lawyers, told the judge he did not want them representing him anymore, and even asked for a mistrial because his lawyers were essentially helping the prosecution. The judge in the case denied Crawford's requests. The jury ended up convicting Crawford and sentencing him to death. His conviction was upheld by the Mississippi Supreme Court in 1998, and he continued to challenge it through various appeals over the years. Crawford's latest challenge, filed in December 2024, relied on a 2018 Supreme Court decision called McCoy v. Louisiana. In McCoy, the Supreme Court ruled that a defendant has a Sixth Amendment right to decide the goal of their defense, including maintaining their innocence. If a lawyer ignored a defendant's clear instructions to plead not guilty and instead admits guilt, it violates the defendant's constitutional rights. This is considered a structural error, meaning that it is so serious that the conviction must be overturned without needing to prove the error affected the trial's outcome. Crawford argued that his lawyers violated his Sixth Amendment rights by admitting his guilt against his wishes, just like in McCoy. However, because his conviction became final in 1998, before McCoy was decided in 2018, there is questions about whether the McCoy ruling applies to his case. This question, whether McCoy applies to older cases on collateral review or appeals after a conviction is final, is what Crawford wanted the Supreme Court to resolve. Crawford started in the Mississippi Supreme Court, though. After the state sought a death warrant, Crawford filed a motion with the Mississippi Supreme Court, arguing that his conviction should be overturned based on the McCoy decision. The Mississippi Supreme Court denied his motion, saying 1. Crawford waited too long, 7 years after McCoy, to raise this claim, and 2. McCoy does not apply retroactively to cases that were final before 2018 because it created a new rule of law that isn't automatically applied to older cases. Then Crawford asked the Supreme Court to step in, requesting a stay of execution and a review of the Mississippi Court's decision. And here is where we get to the present day. The Supreme Court has officially denied Crawford's request for review. Following the denial of his final appeals, Crawford's execution was carried out by lethal injection at the Mississippi State Penitentiary in Parchman on October 15th, 2025. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you next time.